judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
People versus Latzer.
Ready for court, please.
Mr. Root.
Good afternoon, Your Honors. Addressing the procedural issue first, we submit that appellant did not forfeit his ex post facto claim by pleading guilty in this matter. We first submit that because, as a matter of federal constitutional law, a claim such as an ex post facto claim is preserved. It is equivalent to a double jeopardy claim, as was held in Mena, or a due process claim as held in Blackledge.
You make no distinction, Mr. Root, among various types of ex post facto claims. You say any ex post facto claim falls into one category.
I would think that it would. I think they are the fundamental nature, particularly when one looks at the long footnote in Mena that sort of explains the court's conclusion, and when one looks at this court's decision in Michael, which held that as to a constitutional double jeopardy claim that it need not even be raised until the Court of Appeals level. There are various factors that are looked at. One is the fundamental nature of the right. Two is this the sort of thing that is correctable? If relief is granted to the defendant, is there going to be a lot more proceedings or whatever? That is a factor that the courts have looked at.
Mr. Root, this
Yes.
particular ex post facto argument that you're arguing really relates to an insufficiency of evidence, does it not?
No, I don't think so. Yeah, I think it relates to the entire proceeding that occurred here. The grand jury proceeding, the indictment, never could have been issued had the prosecutor's office not decided that the statute could be applied retroactively. I mean, proof of that is given by the fact that when this incident, or when the defendant was first prosecuted back in 1981, they only came up with a one-count indictment, the one count for which there was corroboration. The count that we challenge now, they couldn't even get an indictment on it. Not only was there no corroboration, but the grand jury was not charged as to the need for corroboration. So the entire proceeding was infected by this ex post facto violation.
Mr. Root, to come back then, I take it from your answers to the Chief Judge and to Judge Kaye that you view ex post facto of only one kind and not the traditional kind that we might all be familiar with in terms of punishment for past conduct that is imposed in a latter day, as opposed to here, and this partakes a little bit of the Chief Judge's sufficiency point, where you're dealing with an evidentiary principle and its ex post facto effect, which is different from the traditional ex post facto, is it not?
Well, traditionally there have been four grounds upon which their ex post facto violations have been found, the fourth of which is the one we rely on, and that's, I suppose, the most controversial. There are differences between the courts on that.
But you say the guilty plea waives none of them.
That's correct.
And if the parallel is drawn to insufficiency of evidence or lack of evidence, that in and of itself certainly would be waived by a guilty plea, but not in this context, because this context relates to what you call ex post facto.
Yes. The entire proceeding was an ex post facto proceeding. I think this court has clearly drawn a distinction between sufficiency of the evidence claims and claims that go to the integrity of the grand jury proceedings. Probably the leading case on that is People versus Dunbar. And there were three different challenges made that went to the integrity of the grand jury proceeding, and there were two challenges that went to the sufficiency of the evidence. The sufficiency of the evidence claims were found to be forfeited. The three challenges to the integrity of the grand jury proceeding, one dealt with the instructions given on the agency defense. That certainly is something, instructions given to the grand jury specifically applies here. There was a challenge to the residency of the special prosecutor, and there was a challenge to irrelevant and prejudicial testimony being elicited before the grand jury. Now, the court found as to those three claims, and that's recently been reaffirmed just about a year ago, citing Dunbar as an example for the fact that claims that go to the integrity of the grand jury proceeding are not forfeited by a guilty plea. So when one has something more than simply a pure sufficiency question, this court has held that there is no waiver.
Is the waiver point and the constitutional point really one and the same?
Well, they certainly overlap to a great extent.
If it is ex post facto, it implicates the Constitution and it can't be waived, but the argument is that it isn't ex post facto and therefore it is waived.
Oh, I see what you're asking.
Isn't it the same
Well,
issue?
they are certainly related. I think that the district attorney has tried to relate them a little more than I would agree with. But since the ex post facto claim goes to the integrity of the grand jury proceeding, I suppose Your Honor is correct. If there's no ex post facto violation here whatsoever, I still think that as a pure matter of New York State policy on this issue of forfeiture, that because it goes to the integrity of the grand jury proceeding, that the claim would not be forfeited by the guilty plea. I think there is a distinction. However, I would obviously be in the futile position of arguing solely the procedural point and with no substantive validity.
Well, there is a problem about that, isn't there? Because it's a form of analytical bootstrapping. Because in order to get past the waiver, you've got to find the ex post facto on the merits.
Except for the fact, as I just tried to say to Judge Hancock, that because it falls into the narrow area of the integrity of the grand jury proceeding, and there was not a proper charge here, even if it were not alleged in constitutional terms as an ex post facto violation, I still think there would be no forfeiture.
So the important thing, it seems to me, in trying to analyze the important waiver question is that what you would be forcing us to do, as I hear you in the argument, is that we would have to confront the merits, and the invocation of ex post facto would merely by that invocation eliminate a fundamental block on the waiver principle that a plea of guilty ordinarily brings to bear as a consequence on the defendant who pleads.
As a matter of constitutional law, that's clearly true. But the Supreme Court is held as to certain other narrow rights, two I have cited, and those are the only two I'm aware of, double jeopardy and due process protection against a vindictive prosecution, that a plea of guilty does not forfeit those. And I submit that there is no principal legal distinction that I can see that differentiates these sorts of claims. Just finally on the procedural point, I would say this court has held that a defendant after a plea of guilty can challenge the constitutionality of the statute. And I submit that there is no significant distinction between challenging the constitutionality of the statute and the ex post facto, that is the unconstitutional application of that statute. I submit they fall into the same area, and that consistency in this court's opinions dictate that there be found to be no forfeiture. Turning now to the substantive issue, the key point here is that a conviction was allowed upon less evidence. A number of courts recently have come up with a position that the language in Hopp versus Utah that deals with to lessen the amount or measure of proof doesn't mean what it seems to say. Now, there are no shortage of conflicting views on this. Most of the courts that have addressed this issue in the past 3 or 4 years have split on the issue. But this court has already essentially decided the issue, not in the context of a corroboration requirement, but in People versus Neval back in 1974, this court said, and I just will quote one sentence from the court's opinion, "Statutes that change the rules of evidence so as to require a lesser amount of evidence in order to convict are ex post facto in nature." So submit that this court has decided the issue that has so divided other courts around the country. That there is less evidence required in this matter is clear. The statute itself, the former section 13016, required that other evidence be introduced to corroborate that. Another way of saying it is there was independent proof needed to convict upon these crimes. Now it's interesting, in this area of sex corroboration involving minors, that this is closer, this corroboration requirement, as opposed to, say, accomplice corroboration, it's really closer to an element of the crime. I don't contend that it is in fact an element, but it is closer to an element because it applied to only a very few sections in the law and sometimes only certain subdivisions of those. And the law specifically required that particular proof be introduced to sustain a conviction there. The governor, in signing the change in the law, clearly pointed out that prosecutions that formerly could not be successful now could be because of the requirement for less proof. Even the Nassau County District Attorney's Office, as well as other district attorneys' offices, in documents found in the legislative bill jacket, urged the governor to sign the bill after the legislature had passed it because more prosecutions would be able to be brought because less evidence was required. The further point out that in addition to the fact that there was less evidence required here, there is no doubt that this change was to the substantial detriment of the defendant, a factor that is of significant importance, and one of the reasons that a number of procedural changes that the Supreme Court has considered recently have been found not to be violations of the ex post facto law is because they weren't substantially detrimental to the defendant. I think there is no dispute here that this change works only one way. It's not even-handed, helps the prosecution, it hurts the defense. So I submit for all these reasons, Your Honor, that the conviction on count 6 should be reversed here, and the defendant should be allowed just to serve his sentence on the other count.
Thank you, Mr. Rood. Mr. Whitney?
Good afternoon, Your Honors. If it may please the Court, despite the legal prestidigitation of my opponent, his attack on the grand jury
He has to figure out whether he was complimented or not.
Well, it was a bit of sleight of hand, and this case is before you because of his diligence in this case, but the fact of the matter is that at bottom, his attack on the grand jury proceeding at the trial level was nothing more than an attack on the sufficiency of the evidence. And as this court has held in numerous cases, and the courts of the state have held, that when you attack the sufficiency of the evidence and you plead guilty, you forfeit review of any claim concerning the sufficiency of the evidence.
Why isn't it, Mr. Whitney, more analogous to an attack on the constitutionality of the statute?
Because what he's claiming in the court below was he was claiming one, I guess you could divide his claim in the court below into 3 facets. One, the alleged failure of the prosecutor to put forth corroborative evidence in the grand jury. 2, the failure, and now with regard to that aspect of the claim, certainly this court would agree it's waived by a guilty plea, traditionally waived. Anytime you contest the sufficiency of the evidence in the grand jury, it is forfeited by a guilty plea. The second aspect of his claim is the failure of the prosecutor to charge the jury on the issue of corroboration. Now really, this is merely a reflection on the first aspect of the claim, the sufficiency of the evidence before the grand jury, the sufficiency of the corroborative evidence before the grand jury. Because you have a situation where it would seem odd and somewhat perverse, where if the prosecutor doesn't present sufficient evidence, sufficient corroborative evidence before the grand jury, the issue is forfeited by a plea of guilty. Yet, if he doesn't charge the jury on the issue of corroboration, that isn't forfeited by a plea of guilty. What I'm saying to you is that it's all part of one ball of wax with regard to the corroboration requirement. The evidence before the grand jury and the district attorney's charge, which is forfeited by a guilty plea. Furthermore, a defect in the grand jury, which is non-waivable, is one that is defined in CPL 210.35 subdivision 5. It's one that you don't comply with Article 190 of the CPL. 190 of the CPL gives the prosecutor the right to elect whether to charge corroboration in the grand jury. So under the first contention, that the failure to charge was somehow error in the grand jury, it doesn't meet the statutory requirement. Two,
Go ahead and finish your third point.
Two, with regard to the integrity of the grand jury, there are several cases not decided by this court, but by some appellate courts in this state, that says that the failure to charge corroboration to the grand jury does not impair the integrity of that proceeding. And finally, the third requirement for a defect to survive a guilty plea is that the defendant be prejudiced. Here, the evidence before the grand jury was sufficiently corroborative of the victim's testimony to supply the necessary corroboration. So the defendant was not even prejudiced. Getting to the third aspect of the defendant's claim, which I think is sort of a long way around, but I'm getting to address your question, Judge Kaye, is that any time you put a claim under the shibboleth or the talismanic words ex post facto, that's a fundamental defect and survives a guilty plea. That's not true. Ex post facto covers a myriad of factors, the most important of which are those where the legislature criminalizes conduct which, when it was committed, was innocent. Clearly, if that's what happened here, it would survive a guilty plea, and there'd be no question about that. But here, what happened was a procedural or evidentiary change impacting on the sufficiency of the evidence before the grand jury. It seems somewhat odd and strange for the defendant to come up here and be able to argue to this court that his claim has not been forfeited by his plea of guilty, where the indictment charged the crime, which was a crime on the day he was indicted. An indictment charged the crime, which was a crime on the day he committed the act, which constituted the crime. And there were no different elements, no different degree of proof. Under those circumstances,
Let me just interrupt if I may. As I understand the argument, it's not sufficiency of the evidence that's involved. It's simply that prior to this statute, this was not an indictable offense. This person could not have been indicted. As a result of the statute, which permits an indictment without corroborative evidence, the person can be indicted. Now, let's assume that change definitely implicates the quantum of proof, the amount of proof which is necessary for an indictment. Does that implicate ex post facto constitutional rules?
I have to take issue with the beginning part of your remarks. He was indictable under this offense from the day he committed it. The statute had the same elements. We could have gone into the grand jury with this particular witness, and the grand jury could have returned an indictment. a plea of guilty would have forfeited review of any defect concerning the sufficiency of the evidence before that grand jury, including...
Just wait just a second, because you're making an assumption and may indicate that I don't understand your argument. That is that without corroborative evidence, that a valid indictment could have been returned under the old statute.
Okay. I'm sorry, Judge Hancock, let me make it clear. Let's put it this way. The indictment would have been charging elements of a crime which were elements at the time he had made it. So, assuming that there wasn't sufficient corroboration, it certainly could have been dismissed by a reviewing court who was reviewing the sufficiency of the evidence. However, if a defendant would plead guilty, he forfeits review of the sufficiency of the evidence in the grand jury. He forfeits review of a particular failure of the prosecutor to give a corroboration charge in the grand jury. And that's what the essence of our forfeiture argument is that by pleading guilty in Nisi Prius, he has forfeited review of his claim that this whole proceeding was ex post facto.
Well, your argument then depends on this assumption prior to the statute. A, that the district attorney would have let an indictment come down without corroborative evidence, and I question that. And B, if such an indictment had been returned, that defense counsel would have permitted the defendant to plead guilty to it. And I question that.
Well, defense counsel permitted his client to plead guilty to this charge, hoping to attack before this court the illegality of the grand jury proceeding. And with regard to the fact that we could have received an indictment without corroboration, I cite to you this court's opinion in People v. Kazmarek, which said that the corroboration of a confession, whether there's ample corroboration of a confession, is not reviewable after there has been a plea of guilty. I submit to this court that case is directly on point. But getting to Mr. Root's contention that once he labels his claim ex post facto, that's it. It's a fundamental defect, survives a guilty plea, it can never be forfeited. This court, most recently, on January 28th, in People v. Ruse, R-U-Z, it was an instance where a defendant failed to attack, as being ex post facto at the trial level, the improvision of the penalty provision in the sentencing law. This court held on appeal that that issue was not preserved for review. And there are other courts who have held in areas where the attack relates to sentence that a failure to raise it at the time at Nisi Prius, even though the alleged claim is that the application of the law is ex post facto, weighs review. In this particular case, what he's claiming is not that we indicted him for a crime which wasn't a crime when he committed it. He's claiming that the evidence before the grand jury, because of this procedural change in impacting on the degree or the sufficiency of the evidence of the grand jury, allows him to come before this court even though he's pled guilty. That is not what the law is. It is not, there wasn't a defect in the grand jury that is preserved pursuant to the Criminal Procedure Law 210.35, Subdivision 5. The fact that this is a ex post facto attack, not on a statute which is being applied and adding new elements or adding a different degree burden of proof to the prosecution. The burden remained the same when the crime was committed and after the amendment of 130.16, and the elements of the crime remained the same after the amendment to 130.16 as it was before the amendment to 130.16. Getting to the merits of Mr. Root's claim, the appellant's claim, as Mr. Root told this court, there have been several cases decided in the last few years, two of them from this state, one by Justice Crew in People v. Spearman, just recently the Third Department in People v. Huddy, which decided the issue of whether a retroactive application of the amendment to 130.16 violates ex post facto provisions of the Constitution. Each court said it doesn't. Those two decisions are supported by some out-of-state decisions, one by the Sixth Circuit in Murphy versus Souders, the other by the Kentucky court, which was interpreting the same statute, which was a repeal of the corroboration requirement in that state, which was applied retroactively, and they too decided that a retroactive application of the appeal of the corroboration statute did not violate ex post facto. There are cases from other states and from federal courts which go the other way. I submit to this court that the better view are the former cases, because essentially what the ex post facto law is designed to protect is against the legislature criminalizing an act which was innocent when it was committed, and also enhancing the punishment of an act. That is not, the latter is certainly not pertinent here, but the former is. In this particular instance, the legislature didn't, by amending 130.16 to eliminate the corroboration requirement, didn't change the elements of the crime, didn't change the burden of proof. The people still have the burden of proof of proving him guilty beyond a reasonable doubt.
Excuse me, you 3 times, I think, as I've heard you, said it did not change the burden of proof. There's no question that the statute lessened what the prosecution had to advance to the jury in order to secure a conviction. Is there? Maybe I'm mishearing you, or it's more simple. I'm having
that
trouble.
is the nub of the distinction between the courts that have held that it's not an ex post facto violation to apply a repeal of a corroboration statute retroactively, and the courts that have held that it is. Now, there's a law review article that's cited in my brief from Fordham Law Review, which has a full exegesis of the court's decisions, and that language concerning the amount and the degree of proof is what has been interpreted by the appellate courts who have determined whether a repeal is ex post facto or not.
Forgetting all those authorities, if we were writing on a clean slate, are you still prepared to say for a 4th time that eliminating the corroboration requirement doesn't change the amount of proof and the basis upon which the conviction is secured?
What I'm saying is that certainly to terms of quantitative proof, yes, it does. However, we're talking about how do we interpret Supreme Court language, which has interpreted the ex post facto clause of the Constitution. And the question is, when the Supreme Court said degree and amount of proof, what did they say? And the courts that have upheld retroactive application of an appeal to a corroboration statute says that that language was nothing more than saying that the burden of proof was on the prosecutor and was beyond a reasonable doubt. It didn't address itself to the quantitative amount of the evidence needed to convict. And
Thank you
I'm
very
saying
much.
to this court that that's the better view.
Thank you very much. The matter of Rochester Gas and Electric versus the State Tax Commission.
Ready, court, please.
Mr. Brandt, the question before us is whether or not sales tax should be paid on the removal of this fly ash, as I understand the case.
Yes, Your Honor.
Now, under the statute, they talk about sales tax being levied against services dealing with the maintaining, servicing, or repairing of real property or land. They exclude interior cleaning services, but then include garbage removal. Why isn't the removal of this fly ash the same as garbage removal?
Your Honor, let me just start with the way I understand the issue, and I think it's similar to what Your Honor's understanding. This case has proceeded from the Tax Commission through the Appellate Division on a determination as to whether or not this removal of 10 to 15 truckloads of fly ash every day, whether or not that is trash removal within the meaning of the subsection that Your Honor was talking about. So the issue is one of statutory interpretation, and I guess Your Honor's question is, well, is this ordinary garbage removal? And that is
Isn't it reasonable to consider it the same
as garbage removal, Your Honor?
Yeah.
No, Your Honor. I think it isn't, and I think there's several reasons why that is.
What would you consider it closest to as we read this statute?
Well, Your Honor, let me answer your question directly, which is to say that I believe what it is a transportation service. Okay? That's what I think it is. However, I don't know that I have to categorize it, because the way this statute works, 1105C5, as a matter of fact, the way all of 1105 works is that if it's not included as a...
Yeah, but the transportation contemplates one useful product being transported to another place. This is fly ash, which sounds like garbage.
Well,
I'll
Your
try
Honor-
not to call it garbage, but it's not a useful product, is it?
Well, Your Honor, in this particular case, on this record, the fly ash was disposed of. There are circumstances where fly ash is sold to people who make asphalt, and it's incorporated in the asphalt product, and in that circumstance, the fly ash is used. But I don't think that we have to get hung up on that particular issue per se, because I think that when you examine the statute, Your Honor, you have to take a look at what the statute was talking about, what the statute was addressing when it was talking about trash removal. We start off with a rather broad statement that interior cleaning and maintenance services are excluded from taxation. Now, there's a subset, Your Honor. There's a subset of services within interior cleaning and maintenance services that this fly ash, this trash removal from buildings falls into. And that's the subset underneath interior cleaning and maintenance services, and that is rodent and pest control, window cleaning, and trash removal from buildings. Now, this to me, Your Honor, doesn't conjure up the removal of 10 to 15 truckloads per day of fly ash. In fact, what it conjures up to me, and as I'll address in a moment, it has consistently conjured up to the Tax Commission, is ordinary janitorial services, window cleaning, emptying waste paper baskets, sweeping the floors, dumping it out in the dumpster. The dumpster, someone comes, empties out the dumpster. That is not, as I conceive of it, the common trash. That's trash removal. What we have here is something that far, far exceeds that.
But Mr. Frank, if we look to the regulations, it's clear that the definition or the concept of trash removal is quite a bit broader than what you would have us believe is correct.
Well, Judge Kaye, I would respectfully disagree with that. As a matter of fact, I would take the contrary position. I think that, in fact, the regulations themselves, in terms of talking about interior cleaning and maintenance services, define interior cleaning and maintenance services, and I think it's 527.7C3 IV, little 4. They define it as ordinary janitorial services, interior cleaning and maintenance services. What the Chief Judge referred to in his first comment is no more than ordinary janitorial services. And Judge Kaye, as you're looking at that, take a look at the examples. Take a look at the examples that the Tax Commission in its own regulation uses to describe interior cleaning and maintenance services. It's dusting, it's cleaning, it's waxing, it's oiling hinges, simple...
Are you saying that trash really is limited because of its size or amount or its weight, or is it anything that's discarded because it has no future economic worth?
Your Honor, I think it's in part, Your Honor, you have to look at what you're throwing out. There's no question about that, Judge Tuttle. There's no question about that. I don't deny that. I think you got to do some other things, though, I think, and it's a point that I was going to get to later on. Perhaps I'll address it now. It seems to me that what you have to do is you have to look at the whole activity in context, because after all, when again, if you look at the regulations from the commission's own regulations do not make every type of debris removal taxable. When you look at 527.7B2 of the commission's regulations, those are the regulations defining and describing trash removal, you find there are 3 examples there. One of them is the common type of trash removal that we were talking about before. Somebody empties out the waste paper baskets. And then in the other 2 examples in the commission's own regulations, you find 2 types of debris removal that, in fact, are not considered by the commission to be trash removal. So the fact that it's debris, Judge Titone, may not be dispositive of the issue of whether or not it's truly trash removal within the meaning of this statute. Let me go one step further at that, Your Honor. In fact, and this is a point, Your Honors, that I did not emphasize in my brief. In preparing for argument and reviewing some of the cases that I cited, there are 2 cases that we cited that I think, from this court, by the way, that recognize this distinction. In the case of the matter of Heist, decided by this court, 50 New York 2nd, this court held that the exclusion that interior cleaning and maintenance services found in 1105C5 has been interpreted by the commission, and I'm quoting now, interpreted by the commission to refer to ordinary janitorial services. And in fact, the tax commission in the Heist case refused to give refuge to a taxpayer who said, hey, I am doing interior cleaning and maintenance services. The court said, the tax commission said no, because the services were too big, they were too sophisticated, they were simply not janitorial services, and for that reason, this court upheld the tax commission in refusing to permit someone to argue that some type of service other than ordinary janitorial services should fall within that exemption. That's this court's decision in the matter of Heist. I was quoting from page 444 of 50 New York 2nd. There's another case.
You said that case is not cited.
The case, Your Honor, is cited in my brief, but I don't think that I really dwelled on that point in it. And so I'm making it now. The case was cited. There's another case that's cited in our brief that I think stands for the same proposition. Matter of Delaware Associates. Let me just give a little bit of procedural history on Matter of Delaware Associates. It's a case that's decided by the 3rd Department. There's a dissent in it from Judge Casey. Case goes up to this court. This court reverses the 3rd Department based upon Judge Casey's dissent. So permit me to elevate Judge Casey's dissent to something that's at the minimum approved by this court. Judge Casey, in his dissent, which this court felt to be a compelling argument, the court again accepted this distinction in 110C5 that exclusion of interior maintenance and cleaning services was nothing more than ordinary janitorial services. That's what Judge Casey said. That's what this court approved of. And in fact, the court rejected the attempt that anything, the court basically said that anything more substantial than ordinary janitorial services simply does not belong within the interior cleaning and maintenance exception. Now, Your Honors, if I can go back to one issue that perhaps I went over too quickly, and that is in terms of interpreting this statute. This is a tax statute, and we have some principles of statutory construction that I think we ought to look at here. One is that we have to give a practical construction to the statute, the way an ordinary person would read the statute. We have to use the plain import of the words and reject expansive readings of the statute. I think that, put in the vernacular, you don't let the agency stretch the meaning of a taxing statute. There's also some principles pertaining to tax statutes that say you construe them against the government and in favor of the taxpayer, and if there are any doubts, you resolve them in the taxpayer's favor. I submit that when you take this statute...
Well,
and
there's also the rule about exemptions. Isn't
Yes,
that
Your Honor.
the other way?
Yes, Your Honor. There is language in some of the cases that say exemptions go the other way, and whether this is an exclusion or an exemption, we argue that it's an exclusion. The Commission argues it's an exemption, but frankly, Your Honor, that's probably important in a case that's a close call, right? From our perspective, this isn't even a close call. You have the term trash removal used in the context right next to rodent and pest control and window cleaning. You have the Commission's regulation saying it's ordinary janitorial services. Now, I would submit that if you'd go up to the janitor in this building and you'd say, hey, your responsibilities now include, as the janitor of the building, disposing of 10 to 15 truckloads of fly ash each day, he would say, hey, that's not my job. I'm sorry, Your Honor.
Your example, in this building, it would clearly be unusual, but in a plant that generates electricity, it might be quite ordinary trash removal.
Your Honor, I beg to differ with you. I think that it's important to look at what the activity is, and that's an argument that we've labeled the integrated activity end result test. But I think that even...
It's a fancy name for garbage, isn't it?
Your Honor, we're talking about, the statute talks about trash. You know, I argue that fly ash isn't trash. But, Your Honor, if I can just briefly...
Well, your time has expired. If you could just respond as quickly as possible, please.
Yes, Your Honor. Seems to me that you have to look at the entire activity in context. And that's what the Commission does in its own regulations. You have to look at the entire activity. This activity isn't merely just trash removal. This is the end product of the production of electricity. The disposal of this fly ash is an integral, an essential part of the production of electricity. It truly cannot be separated out, and that's what the case law consistently holds. Thank you, Your Honor.
Thank you very much, Brand. Mr. Holtzman? Mr. Holtzman, here we're concerned with a hazardous material that's taken and processed into a solid and then buried in a landfill.
Only with regard to one point, Your Honor.
With respect to that point,
Yes.
aren't we dealing there with changing the material, processing the material from a hazardous to a non-hazardous material?
Not in every respect, Your Honor. There are, that's our liquid waste that comes in. There are two things that might happen to liquid waste. One is we apply Speedy Dry. Speedy Dry bulks it up so it can be buried. The other is it has to go through a water processing, and we filter out the bad part and segregate that from the good part.
That is a processing.
There is no question about that. I would admit it's processing, Your Honor.
And then if it's processing, isn't it rational for this to be termed as tangible personal property?
Oh, I think it's tangible personal property, Your Honor, but the bottom line is it's not 1105C2 type of processing at all, because what we have here is something that we're hardly processing for the owner. 1105C2 is based upon the owner bringing something in, and you either process it, you fabricate it, you print it or do something like this, and in the normal course you would fully expect that that person would take it back.
In a sense, Mr. Holtzman, it is being processed for the owner, isn't it?
It is not being processed for the owner because the owner no longer owns that. When it comes into the Seacoast landfill, land site and waste treatment facility, it is tested. When we test it, we see if it conforms to the hazardous waste that is designated on the manifest. If it is, we accept it. At that point, it is ours. I know that respondent in his brief says that it happens to be the customer's until we process it, and that is quite incorrect, the reference at page 18 of his brief. This is hardly the customer's property that we are performing a service on. Everything that you find about 1105C2 really relates to retaining the property and doing something with it after the processing. The person doing the processing doesn't keep the property. It's, I go into a store and I buy a suit. I pay $300 for it. I pay a full tax on the $300. If I buy cloth for $100, I pay tax on the $100. If I now take my cloth to the tailor and he charges me $200 for preparing the suit for me, I can't avoid the tax on that additional $200 for her services. And that is what 1105C2 was intended to do, complement 1105A. May I talk about another very important part of our case? That can be narrowed down to the single question of whether the service performed by Seacoast at invoice number 6874-5 at page 141 of the record is taxable. That invoice shows that a Seacoast customer itself brought contaminated earth to the Seacoast landfill. This is exactly what the State Tax Commission referred to in its decision, paragraph 6 of its findings of fact, when it's describing one of our services. It says, bulk waste, typically contaminated soil, arrives in dump truck loads, is taken to the secure landfill and buried. We say this is not a taxable service, and the state agrees this is not a taxable service. It is abundantly clear from counsel's brief. He says that when the customer delivers the waste, no transportation, and it is not processed, in other words, bulk or solid waste, there's no taxable service. He then says, however, that Seacoast never proved on the record that any of the invoices in the test sample were taxed solely on disposal charges without transportation or processing. This is incorrect. Invoice 6874-5 is clear on its face to be without transportation and without processing. It
Is that
involves...
the invoice you just referred to?
Yes, it is.
141?
Yes, it is.
Thank you.
It involves contaminated earth, which is the State Tax Commission's own example of bulk waste, which is merely buried. The next issue involves the liquid waste that we were talking about before, and I would like to direct you to invoice 4413-5 at page 114 of the record. That will very succinctly narrow the issue to a certain service, showing that a Seacoast customer itself again brought 693 gallons of oil water sludge to the landfill. This is what we were discussing before. It'll either be solidified or it would be treated. And this then gets into the very question of who does own this property, if you are talking about the owner processing it. And back to what I referred to before, it is on page 18 of respondent's brief that he implies that the customer is the owner until the processing is complete, and thereafter it belongs to Seacoast. This, he says that when Seacoast cannot accept the waste for burying until it's processed, and cites page 64 of the record. This is completely erroneous. The record says no such thing, and what the record does show is that Seacoast tests everything, and if the test matches the manifest for the hazardous waste involved, it then accepts it. So Seacoast at this point, without any stretch of any imagination, is not performing any processing on tangible personal property that is owned by a customer.
What do the amounts, the $83.16, $83.16, and the $28,
In a tax point of view?
84, what are those What are those billings for?
The $28 is the unit price for receiving earth and burying it.
So that's payment for a service.
Yes, it is. And this is a service, Your Honor, which is not enumerated. And this is the service, in this example, 100% agreed by everyone that it is not taxable, but the question is, it is not a matter of record in this case, and that's what I disagree with. But basically, everyone agrees that this is not a taxable service. When the customer brings it, we receive it and bury it. The other invoice you mentioned involves some processing.
That's $83.16. The same thing? Is that for receiving?
That would be for receiving oil, water, sludge. And I don't know if that had speedy dry added to it, or whether that was put through the water treatment facility. But there was that degree of processing with regard to that, not in the first.
Now, that's a service also.
Yes, it is. However, services are not taxable unless they are specifically enumerated. The 1105C5 issue is the trash removal from buildings issue. And if we forget for a moment the question of whether hazardous waste is trash, I would think that to understand the issue, we should recognize that Seacoast's principal activity is operating a secure landfill and waste treatment facility. And again, everybody seems to agree on this. The commission agreed at paragraph 4 of its findings of fact, page 183 of the record. The appellate division also agrees in the second paragraph of its decision, page 226 of the record. But then, everything gets turned around. The appellate division says that the record reveals that the transportation of waste is an integral part of Seacoast's waste removal service. Yes, sir.
No,
The appellate division,
if those billings included transportation, would it make a difference?
wouldn't make any difference at all, Your Honor. Our principal business activity is that of operating a secure landfill and a waste treatment facility. It just so happens on our facts that Seacoast doesn't own a truck in the world. It doesn't have anything to do with the normal type of transportation. If a customer wants something, it'll arrange for it. People bring it in themselves properly because it has to be manifested. But it really wouldn't make any difference because the real answer is the end result test. That is really the answer. And I can describe the end result test as Mr. Benjamin has very nicely put in his brief. I think that's on page 13 of his brief. It says, if the end result is not taxable, then neither is any activity essential and integral to this result. I must qualify something. It's not page 13 of the state's brief in our case. It's in the Rochester case. But anyway, that's the end result test. Now, if you will recognize that when Seacoast receives the contaminated earth and buries it, that is not taxable, then use the end result test. If we go and get the dirt and bring it back, or if somebody else brings it in and transportation is introduced, the end result is still a non-taxable service. This is the building contractor's case. That's what the state cites. Building contractors was a situation where there was hauling of debris from a construction site. And the question was, is this taxable as trash removal? Or, because the construction site involved a capital improvement, which was not taxable, is the hauling of the debris not taxable? The conclusion, the end result test, because the end result, the capital improvement, is not taxable, then the hauling of the debris is not taxable.
I gather that there are some invoices in here which charge, which contain billings for hauling?
Every invoice that is in here, Your Honor, if it has hauling, it is separately stated. But I would maintain that that is quite irrelevant to the whole.
But that can't be taxed either.
Under the circumstances of being in the principal business, and assuming the principal business is non-taxable. Now, perhaps I'm there only halfway, because it's not only contaminated earth that we have. I don't yet have agreement that 1105C2 on the processing would be not taxable too. But it certainly would be a strange situation if my contaminated earth is not taxable when I dispose of it, and therefore when the trucker moves that in, that's not taxable. But if I have the liquid waste, and that's taxable because of the processing, and the same fella and the same truck brings that along, that's taxable, that raises quite an obvious problem, and I think didn't see the light.
Thank you very much, Councilman. Mr. Benjamin?
Good afternoon, Your Honors. I think I ought to start off by addressing RG&E's contention that what is involved here is an ordinary janitorial service. First of all, what RG&E fails to point out is they haven't read the full statute, that we're talking about an exception to the exclusion. It says other than trash removal from buildings. Therefore, trash removal from buildings is brought back into the general category of maintenance service. And a maintenance service is, once again, keeping a building in a condition of fitness, readiness, or efficiency for use, and that's exactly what happens here. So the fact that there is an exception to the exclusion brings it back into the general category of taxability. That's the only way that that statute can possibly be read. In other words, let me explain it this way. It's a bit confusing. There's a general area of taxability that includes maintenance services, servicing real property, and repairing real property. Then there's excluded from that interior cleaning and maintenance services. That means that but for that exclusion, that would be an ordinary maintenance service that would fall back within the area of taxability. But then accepted from the exclusion is trash removal from buildings. That, once again, brings it back into the general category of maintenance, and therefore it becomes taxable again. It's really very clear once it's read. And insofar as the heist case is concerned, and for that example, National Elevator is another case that also deals with this, and the fact that those cases, in those cases, this court interpreted that provision as applying to ordinary janitorial services. Once again, this court was interpreting the exclusion, not the exception to the exclusion. So fine, ordinary janitorial services includes interior cleaning and maintenance services. But here you have a situation where what's happening is excluded from that. So, number one, if RG&E is right, and it includes only regular trash removal from buildings, the ordinary situation, and of course we contend that there's nothing in the statute which has to deal with how much trash is collected, but if that's the case, then it's taxable because there's an exception to the exclusion. But let's say that that's not the case, and let's say that this is not the normal situation because this involves hundreds of tons of waste. Well, once again, it's brought back into the general provision of a maintenance service. I mean, it doesn't help RG&E to argue that interior cleaning and maintenance services only apply to ordinary janitorial services. Either way, this is a taxable situation. It's a bit confusing. I've tried to make it clear, but really, I think that our analysis is correct, and it does fall within the general maintenance service statute, and of course the regulations make that clear. The regulations specifically say that all services of trash and garbage removal fall within maintenance and therefore are taxable.
The regulations, and particularly the examples, Mr. Benjamin, seem to focus on janitorial type services. What's the best analogy you can point us to the situation
Well, there's one regulation that talks about the fact that the carting of waste from one area to another is taxable, and I think that that's the situation. I disagree with RG&E's analysis of the regulations. The regulations point out two situations that are not taxable. Neither of those situations, Your Honor, has to do with whether or not what was being carted was trash. One has to do with whether or not what was being carted had resulted in the end result test of a capital improvement, which once again is the building contractor's case. And that has to do with the legal definition of what's being taxed here in terms of the end result. And the other one has to do with whether or not this was a regular service. Neither of them went to the issue here of whether or not what's being carted is trash. And we believe that the statutory language is clearly broad enough to cover the worthless byproduct of coal combustion, which is fly ash in RG&E's case, and in Seacoast International's case, it's the worthless byproduct of manufacturing. It's hazardous chemical waste. Insofar as the argument that this is a transportation service is concerned, we submit that, once again, it's worthless products that are being transported to landfills. You don't have a situation here where it's the transportation of a useful product. Trash removal, the very words trash